not only interactive but informative for everybody. We are happy to welcome Mark, Chris, and Dan from our member law firm, Hilger Hammond. As you all know, Hilger Hammond has deep experience in construction law and commercial litigation. We are going to turn the discussion and the moderating over to Mark. So with that, Mark, are you ready to start?
You bet. Can you hear me okay?
I can, yes.
All right, great. First, I just want to thank Nell and her team for putting this all together. It's been an interesting process for me, not being the most technologically advanced, but thankfully we have them to help us all get through this and do it in an organized way. So like Nell said, part of our goal here is to do something different from what we're seeing other people do. And the main thrust of that is to find out from all of you that are participating today, what issues are on your mind? What are you guys dealing with out in the real world? How does COVID-19 impact that? What questions do you have? What strategies can we as a collective group discuss and come up with that helps everybody? So to that end, what we really want to do is stay away from just having me and Dan and Chris be a couple of talking heads up here that tell you stuff that you may not be interested in. And part of the reason for that is, as you guys know, this is a evolving situation. The things that were important last week may not be and probably are not as important this week. So with that being said, feel free to ask any questions anytime you want. If you saw in the beginning of this, there is a method for doing that in the question and answer option of the Zoom application. Feel free to post it there. And we'll just answer it as we can. And I'd like to be able to call on a few people if I can. So if I put you on the spot and you don't like it, you can chew me out later and I'll buy you a cup of coffee when this whole thing's over. So here are some things that are on my mind. So far in the coronavirus crisis, from a construction standpoint, a lot of people have been focusing on how does this impact us right now. The initial phase of this with the issuance of the executive order from the governor of Michigan really caused a lot of people to pause and say, can we continue working? Some people say yes, some people say no. It depends on the project, depends on what you do, depends on what your people do, depends on how the owner and the contractor, if you're a subcontractor or a upper tier subcontractor, is manage the designation process that will drive those issues. What I'm most concerned about is in a week or 2 weeks or 3 weeks or a month, how does everybody redeploy? And what are the issues that are going to come down the pipeline that we haven't addressed yet? So we can get out in front of those and be proactive as opposed to constantly being in a reactive state. A couple of issues there that I'll just throw out there to get some discussion going are claims process management for delay and sequencing issues. Good, we're getting a couple of questions here, so I'll work these in just a second. I think the claims process and how people are notifying contractors or upper tier subcontractors is going to be probably the next big issue that'll happen. There's a couple of dynamics that play into that. Most of us in West Michigan have an appreciation for the collaboration of the contractor and subcontractor community, as opposed to some of the more difficult relationships that exist outside of our geographic region. And one of the concerns that I have about that is how people manage the claim or change order request process for extensions of time, for suspensions of work. If people rely on their relationships alone, my concern is that they will not properly document a need for a claim, that if things go sideways later, we will not have the information necessary to actually perfect the claim and obtain an extension of time. And possibly the most important part of that whole claim process is the notification aspect of the subcontractors issuing claims or change order requests for extensions to this project schedule, not just to preserve their rights, but also to put the contractors and CMs on notice that they in turn need to do the same thing. And what I've been hearing in the contractor community is that a lot of the contractors, or some of them at least, are not having the same perspective. A lot of them are kind of taking the wait and see approach. And in instances where claim notices or change order requests for project schedule extensions have been issued, they've actually been viewing some of those situations as adversarial when it really shouldn't be. So now that I've all talked about that, let me throw it out to the group, and I'll just wait to see if any questions are posed, and we can circle back on that. In the meantime, a couple of questions that have been asked. Let's see. First question, can COVID be considered force majeure? The short answer, yes, it can. For those of you that don't know what force majeure is, it's a term of art in the legal world that basically means that something outside of your control, like a pandemic or an executive order that shuts down all the construction projects, impacts one of your contractual duties to the extent that you cannot perform that contractual duty because of the event that makes it impossible for you to do so. So the short answer is yes. The long answer is it depends. Most construction contracts and most commercial contracts in general have force majeure clauses and provisions. And depending on how those are written, they may include pandemics or they may not. And so the best way to analyze that is to first ask yourself the question of why does a force majeure provision matter? Really, I view a force majeure provision as a defensive posture rather than a proactive or offensive posture, which would be to go out and submit a claim for an extension. A force majeure clause is really an excuse for non-performance. And the only reason you get to non-performance in the first place is because you haven't extended the schedule out. So I think that the better way of looking at force majeure is to defer that issue and take the first step of submitting a claim for an extension of time and or money, because frankly, there could be an extension of a need to modify the contract amount in order to anticipate some of the things that may happen when we all go back to work. For example, social distancing may still impact how all of you perform your scopes of work. So that may in turn affect productivity, and that in turn will obviously affect the cost of labor and your cost on a project. Similar question, is COVID-19 considered an act of God? Really, that's kind of the same question of force majeure. You could take the position that it is an act of God or that it isn't. In any event, what you're really talking about is another basis to excuse somebody's non-performance under the contract. And to be honest with you, I don't know of any authority that has taken the position so far that this pandemic or any pandemic is an act of God. But that is an argument that I anticipate people making if they don't preserve their claims now and are forced to deal with a situation where they have to defend their non-performance as opposed to going out and correcting the project schedule and getting an extension of time now. So great question so far. Another question is, and this really goes to cash flow management and how this situation affects everybody's operational capital and ability to continue operating during project shutdowns. The question being, is there anyone who did not apply for a payroll protection loan or grant? And if so, why not? I'll just throw that out there to the group. It's a very interesting question. The little bit that I've heard from people is that people are pursuing them. And as you've probably heard on the media, it's not exactly a seamless process. But why don't I turn this over to Chris Nyenhuis, who is the resident expert on the SBA stimulus package loan grant process, and he can give you maybe a couple of optics on what he's seen in the last couple of days.
Sure. Thanks, Mark. So I heard last night in the Trump press conference that $70 billion has been allocated so far of the $349 billion. And I was on a call last week where I learned that there are a potential 22 million applicants for that $349 billion. Frankly, I don't see a downside to applying for it. It might be the rare instance where, if it sounds too good to be true, it's not. But, if it's forgivable loan, it's effectively free money. I saw this morning there's talk of as early as next week, they'll be appropriating an extra $250 billion to that. So obviously there's been a kind of a mad scramble to get in line and to get that money before it's gone. But there might be some more help on the way if you don't get in line fast enough. There were, I forget the bank, but somebody applied and they were 10,000 in line. Of course, never really rely on Congress until it's done. So, our advice is to still keep applying for it. There's been reports that some of the bigger banks were a little more reluctant or really wanted to get their ducks in a row with the process before they opened up the application or really got serious about it. So there maybe community banks might be your best option if you're trying to get in line. There's no downside to applying in multiple places, other than you might be farther back in line if you're at a bank that you don't have a relationship with. But I think some of these community banks see it as an opportunity to get FaceTime with you or to increase their book of business. So whether you're with Fifth Third or Chase, Wells Fargo, some of the bigger ones, it's also probably worth your time to poke around a little bit to see who else, smaller banks, are giving those up. So to explicitly answer your question, I don't know anybody who didn't, or maybe for philosophical reasons might not because they just don't want government money. But as a practical matter, I think everybody should be applying for it.
We got a question, I think we skipped over from Mike Walkus. Did Governor Whitmer sign legislation to broaden the definition of essential work on Tuesday? Had heard she was going to make Michigan's law equal to federal so more trades can return to work. So I can briefly talk on that. The way the interplay works is that there is no federal law. There's no isolation. There's no quarantine. There's no shelter in place on a federal level. President Trump has left that up to states to make a determination for stay-at-home or shelter-in-place orders. So what Michigan has is Executive Order 2021. That was the original executive order that identifies what critical infrastructure is and what critical infrastructure workers are as well. So what that executive order does is it references a memo from the federal government, from the Cybersecurity Infrastructure Agency, that defines what they believe is critical infrastructure work during the COVID-19 response. So that's not law, but what Michigan Executive Orders does is adopts that, and it basically mirrors it and identifies all of the industries that it believes are critical infrastructure that are the same as the federal memo, and then also adopts the federal memo to the extent that that is more expansive than what's identified in the executive order. So no, really there is no federal law, but also the states Michigan has mirrored the federal approach by adopting and referencing that memo in the executive order.
I saw another question come up on the PPP program regarding tracking the funds and documenting how they're used once you get the money. Yes, I would either segregate it or create a separate account because I think the rubber's really going to meet the road on the back end. The application is about a page. to get the money, but there's probably going to be some pretty strict scrutiny on the back end to see if it's actually forgivable. So yes, I would keep it in a separate account, and that's where you would cut your checks for payroll, for utilities, rent, and mortgage, and everything that's covered under that loan, because it's going to be the easiest way to document what you're doing. And I think as long as it's clear, and it'll save you time, that's probably the best practice once you get that.
Chris, can you follow up real quick? There's another question here about how companies are handling their workforce if they receive the loans, such as keeping everyone on the payroll, whether working or not, and how to deal with working employees versus non-working employees. Can you touch on that a little bit?
Sure. So I don't think we've gotten to that point yet because the money hasn't actually been distributed. But the point of it isn't to get people working. It's just to keep people getting paid. So, that will be up to each company and how you want to deal with your employees. There's no requirement under the act that you have to keep people working or that they have to do anything to earn the payroll. It's just that you can't change, the number of employees, or you can, but it affects how much is forgiven. You can't change the number of employees or cut back on how much you're paying them. So it's really up to the recipient how they want to decide for themselves who's going to work and who's not going to work. Obviously, that can cause some issues, but we haven't really seen that yet because the funds aren't flowing.
Great, thanks, Chris. We got another question back on the issue of what I would describe as schedule issues or claims. The question being is, in addition to sending out delay notices, should subcontractors also be sending out change orders for extended schedule, or should we wait until we actually know what the final schedule impact will be? I guess my perspective on that is ask now. You already know that there is an impact. And what we're really dealing with later is how extensive was that impact? Were we talking about a couple of weeks requiring demobilization, remobilization, or are we talking about a month? And we all know that the longer this stretches out, the more that final impact will be. But I think it's high risk to do nothing. And it's also high risk to take a one size fits all approach to this, because every subcontract, every construction contract is probably slightly different. And when you start talking about change order requests, claims, those kind of things, the processes for those can be different from project to project. If it was me sitting in any of your offices trying to navigate through this, the first thing I would do is make a list of every project that we had open. Then I would compile the contracts to those projects. Then I would go through each contract and map out what is the process to make sure that we're covered for schedule and contract some adjustments or modifications later. Sometimes it may require you to submit a change order request. Other times you might want to just go right to a claim. And it really depends on what your contract says and how you want to facilitate asking for the modification. There is a lot of risk in just issuing a change order request, depending on how that ends up getting processed. One tact could be to issue a change order request, wait for the change order request to be denied before submitting a claim. I think probably a safer route is just to submit a claim now. And the reason for the uncertainty about how to handle this in every particular situation is that the contract language is going to be different. An example could be, sometimes when I've written contracts, I've required contractors or subcontractors to actually submit both change orders and claims on specific forms. And so when I do that, when I draft a contract that way, the form will be attached to the contract. And the reason I do that is to make sure that when my clients receive a change order request or a notice of claim, we know exactly what it is. We can avoid the whole issue of, well, we sent you an email asking for more time and you didn't answer it, or you responded to it and said it's fine. That will not always satisfy the requirements for a contract modification. And so you have to be very, very careful about how you handle change order requests and claims. And keep in mind, this is a common mistake that contractors and subcontractors make even outside of the pandemic situation, which is they focus on the impact and only ask for an extension of time or an increase in money, not both. This is a situation where I would ask for both, mainly because you don't know. When everybody goes back to work, I would operate with the expectation that productivity is going to go way down. And so what that will mean is either a schedule compression situation where you have to staff the projects more intensively than you'd planned on, or you end up working overtime, those kind of things. Well, both of those options cost more money. And so I think you need to hedge your bets and ask for extensions of the schedule as well as to modifications of the contract time. And some of those things may not get fleshed out until later, but it's better to ask now. The worst thing you can do is do nothing. Let's see. Dan, we have a question on the federal pandemic unemployment compensation part of the CARES Act. Can you touch on that a little bit?
Sure. So the question is, if an employee has been written off work by a physician due to them being high risk, is that processed through COVID-19 FMLA? Is that sick time / FMLA deducted from year-end taxes quarterly? So let me unpack that a little bit. So I'm assuming that if they've been written off by a physician due to COVID-related issues, that's what the question's based on. And this all goes to what you all probably heard of, that's called the Families First COVID Response Act. That was passed by the federal government. It was effective on April 1st. And really that contains a lot of information, but two main provisions that really apply to employers, which is an expansion on FMLA, Family Medical Leave Act, and there was also an expansion on the Paid Sick Leave Act. So a lot of people get these confused and get them blended together, but it's got to be two separate analysis under each one for employees that are trying to take off work or be paid leave due to COVID-related issues. So the first is the expansion to the FMLA. I'm going to keep this pretty brief because I could talk about this forever, but basically there's qualifying events for each one of them. The qualifying event for the expansion to the FMLA Act is basically when a employee has a child at home that they need to care for because the daycare facility or their school was shut down due to COVID-related issues. So that applies to everybody in Michigan. Governor Whitner signed the original executive order and then an expansion on the executive order that all schools are shut down to the end of the school year. So that's the qualifying events for the employee to take leave under the FMLA. FMLA gives 12 weeks of paid leave at 2/3 of the employee's rate of pay for the hours that they're scheduled to work. Now, there's tons of information about how to calculate that, and I won't go into that right now. But again, that only has to deal with the parent who is staying home and caring for their child and is unable to telework because the child's school was closed, basically. So that's the first one. So under the question, if an employee was home because their physician said you're symptomatic or you need to stay home and isolate or quarantine yourself, that would not allow them to qualify for paid sick leave under the FMLA Expansion Act, under the COVID Response Act. But the second part is the expansion to the Paid Sick Leave Act. So that's a completely different section, and there's a different qualifying event for that. And the qualifying event for that, I'll just pull it up here really quick. There's 6 different qualifying events First one being the employees subject to federal, state, or local quarantine or isolation. That doesn't really apply to the question, but we are all subject to state quarantine or isolation under the shelter-in-place executive order. But the second qualifying event for paid sick leave is the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. And then the third is the employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis. So those are two triggering events under paid sick leave. So under the question, if a physician instructed the employee to stay home, or the employee was concerned about because they were experiencing COVID-related symptoms and were seeking medical diagnosis, they would qualify for paid sick leave, which is 80 hours up to 10 days of paid leave. So it's substantially less, 2 weeks, than the 12 weeks offered by the FMLA Expansion Act. And there's a bunch of nuances about how to calculate the hours and the rate of pay for that too. But yes, under the Paid Sick Leave Act, they would qualify for up to 2 weeks, 80 hours of paid leave.
And I think I saw a question about unemployment under the CARES Act, and whether the $600 from the federal government is prorated based on, I think, their typical wages. No is the answer. And yes, it does lead to a perverse incentive not to work, because it's possible that with the state unemployment benefits, in addition to the $600 a week, you could be making more to not work. How people will work through that is yet to be determined. But you know your people, I guess. The sense that I'm kind of getting is that people are ready to get back out there and do stuff. I don't know if there's as much of, I guess, an incentive to be at home and getting money for doing nothing. I think people have kind of had enough of that. So, sitting here as a lawyer, there's not much I can tell you other than, yes, it's possible to make more on unemployment than it will be to be working once all these programs kick in.
I think there was, one more thing I didn't address in that last question, which is, what's the tax implications of the benefit of paid sick leave and family medical leave under the COVID Response Act. There is in the Act a tax credit, dollar for dollar, for every dollar that you pay out to employees for paid sick leave or FMLA expansion under the Act. The way you do that is that you calculate that and you can offset it against your payroll taxes. So you can do it quarterly when you file your tax liabilities, and I think it's on a Form 941. On that form, you can take the money that you have paid to employees for paid sick leave and FMLA, and offset that against your tax liabilities, payroll tax liabilities.
Thanks, Dan.
Yep.
I'm sorry, did somebody else have a comment? A couple other questions received kind of offline of the system here relate to when we all go back to work, what are the greatest legal exposures, I guess is what the question is, that everyone's going to face. The question was framed, I think, a little bit more in the context of safety, but safety is one aspect of, I think, the bigger basket of issues that may be facing people when we get back to work. On the topic of safety, there has been some information that MIOSHA and OSHA has released. Basically, the MIOSHA information relates to the OSHA standards. The little bit that I've seen people talking about that really relates to how should the safety protocols and management of the safety program on a construction site be handled in light of the coronavirus pandemic. And so a lot of people have been discussing whether the existing OSHA or MIOSHA standards apply, and if so, which ones would be the ones that would jump out to deal specifically with this. Basically, there's three of them that exist right now. The MIOSHA standards, or MIOSHA's issued some guidance that basically incorporates the existing OSHA standards. I'm happy to circulate the employer guidance on this, which you might want to take a look at. Anybody that wants that, feel free to send me an email or call me or text me or whatever. I'll email it to you today. But basically, there's three components to the OSHA standards as they exist right now that could relate to how we manage the coronavirus situation going forward. The first one is the personal protective equipment standards. Those are general standards. You guys probably already understand them and deal with them anyway, but the specific ones that are going to probably come into play in a variety of ways deal with respirators, gloves, and the same PPE that everybody's talking about as it relates to the pandemic. And whether or not that's necessary on a construction site or necessary for a specific trade, there's no real guidance on that. There's no black line that says you have to do it in this situation, but not that situation. So in that context, I think you follow that as closely as you can, especially as it relates to respiratory protection. And keep in mind that nobody has the absolute answer on this. So be conservative, safety first, and apply those mentalities. The next one is the general duty clause. Really, all that requires is that employers must maintain a safe place of employment. And all that really means is that you have to avoid recognizable harms. Obviously, coronavirus is a recognizable risk of harm that exists, frankly, everywhere right now. And so, that particular standard is just going to align with all the other recommendations that are being issued and those kind of things. There's a couple other things. The OSHA bloodborne pathogen standard, people are looking to that for some guidance in terms of how to deal with the coronavirus situation. Obviously, this is not a bloodborne pathogen per se, but it does provide a framework to help control some of the vectors or sources of the virus. And so those are the three safety issues. The bigger risks that I personally see, and this is opinion, not fact, going forward are going to have to do with the financial aspects of projects. This situation has definitely put pressure on everybody: owners, contractors, subcontractors, architects, engineers. It doesn't matter who you are. It's impacting us now. As things stretch out, and the unknown here is how long is this going to go on? If we're talking about another couple of weeks, that's one thing. If we're talking about another 6 weeks or 2 months, that's something different. But everybody needs to understand that the financial pressure will drive a lot of what I would describe as the legal exposures for liability. And so we all understand the payment cycle and the lag in payment. And right now, you guys are probably, hopefully, still receiving some payments for the work you did before the shutdowns. And you're going to probably have a period where you don't get very much money. But the bigger risk when we go back to work is that we're really starting from scratch financially. And what I mean by that is that the first day that you go back to work, you're probably not going to be able to bill for that until 3 or 4 weeks later. And once you bill for it, you probably won't receive payment for that work for another 60 to 90 days. So we've now stretched out a standard payment cycle for ongoing project from 60 to 90 days to 90 to 120 at least. And so that's going to put pressure on people's cash flow, their ability to maintain operating capital to do the work. Now, if you stretch that out even further and broaden out who we're talking about here, the owners is the source of capital for you guys on a construction project. They're going to be experiencing a tightening of their cash flow because some of them, at least, depending on how they are capitalized, their main source of capital for financing or funding these projects, which is the same money that you guys rely on for operating capital, is going to be eroded by some of the carrying costs. So now that a project goes from, let's say, a 12-month duration to a 13 or 14-month duration, the additional interest costs on any financing, additional taxes, insurance costs, operational costs of the owner, all of those things are going to stress the cash flow cycle and system. And so there's a risk that people get delayed payments, short payments, those kind of things. And my biggest concern about those dynamics is that each one of these issues, an owner's slow pay or short pay to a contractor obviously translates to a short pay or to a slow pay to you guys, sometimes even magnified after going through the contractor entity. And that can stretch these things out and increase the pressure. And so I think that we need to be prepared for that, because that dynamic will drive the legal liability issue. The legal liability issues being who's responsible for all this and how do you recover from them if you need to. That's bringing it back to the issues that we started out this conversation on, being claims and change order management. Somebody will be left without a seat when the music stops. And it'll either be the subcontractors if they don't issue claims and change order requests for scheduling issues and modifications of the contract sum, or it will be the contractors if they don't respond to subcontractor claims and change orders by in turn submitting their own upstream claims and change order requests. Ultimately, the owner in a philosophical sense is the one that should bear this risk. Unless the contract calls for something else that doesn't permit any extensions of time due to pandemics or force majeure issues or acts of God, then the owners assume this risk when undertaking the construction project. When you guys bid these projects, you didn't anticipate that a project of a 12-month duration would be shut down sometime in the middle of the process for a month or two. Neither did the contractors. Frankly, the owner didn't probably anticipate that either, but the owner ultimately bears the risk if the contract is followed and it's written in a way that allows for flexibility for schedule extensions. That is the biggest risk that I see. In terms of safety, the industry is very, very good at finding out ways to manage workforce safety. And you guys in particular, you take it seriously. You have your own safety committee within this group. You guys collaborate with contractors and CMs. You're in a good position to do that. The biggest problem we have in the safety perspective right now is uncertainty. And so we're all going to have to do the best we can. The thing that we don't have as much uncertainty about is the need for claims and change orders. And that's what I would focus on right now, because that will translate into bigger issues later. We have another question here about whether or not construction managers have started asking about how to get subcontractors back to work and to what extent can they enforce schedule is of the essence clause. Couple of questions that are embedded within that. First of all, the time is of the essence clause, that really doesn't do anything other than fixes the dates in the contract as hard dates. It's a legal term of art. It's a legal clause that lawyers use to draw a distinction between not having that clause, which means that even though there's dates in the contract, generally speaking, your performance for time measured standards is going to be a reasonable amount of time. And so lawyers want to really define time periods. We don't like uncertainty. We don't like the ambiguity of what is a reasonable amount of time, because those are the things that get expensive to litigate. So lawyers put in time is of the essence clauses to lock down timeframes and require their strict adherence. So that's how that part works. Now, in terms of GCs or CMs asking to get subcontractors back to work, I have seen that a little bit, and what I've seen leaves me with the perspective that there are some contractors and CMs out there that are very concerned about not being able to work. I mean, we all are to varying degrees, but some of them are getting very aggressive in terms of how they're trying to facilitate either continuing to work a couple of weeks ago before the work shut down, or even after the executive order was issued. And so some of that has been some, I guess, creative ways to read the executive order, if you will. Others have been doing things like asking owners to just carte blanche issue a letter designating the project and the contractor as critical infrastructure or essential workers. The few times that I've seen an aggressive contractor situation like that, generally speaking, owners are doing what I would say is the right thing. They're following the executive order. And unfortunately, what that means by and large for our industry is that the majority of projects are stopped. Unless you're one of the lucky ones that fits into a very narrow exception, these projects are going to stop. Now, in terms of how to get subcontractors back to work, I don't know if the question was framed in any particular context, but I'll take it in the context of today. If a general contractor is continuing to work and there's a dispute between the contractor and subcontractors, or a subcontractor and lower tier subcontractor about whether or not the project can continue, that's a whole different situation. Then you really are putting the needle on the issues of force majeure and whether or not there's been claims and change order requests for schedule extensions or other modifications to the contract, and whether or not the contractor really wants to be aggressive and try to hold subcontractors to the performance standards under the contract. If they really want to get aggressive about it, they can certainly send out notices of default for failure to follow the schedule, not staffing the project, threats of workforce supplementation, all those nasty things. All that will really do, and to be clear, I haven't seen that. I haven't seen contractors or CMs getting that aggressive with it. But if that happens, you have to treat it like any other time when that happens, and you have to respond accordingly. And sometimes that response may be you go back to work. If it's a project where that's permissible, then absolutely. You go back to work and you have to work through those things. If it's a situation where the project is not permitted to continue to go on, then you really have to make some decisions about how aggressive you want to be with it, because anybody that works and does so in violation of the executive order is exposing themselves to liability, frankly, criminal liability. If it was me, I'd be much less concerned about the monetary fine than I would be about spending a few days in jail. I think that this is a violation of the executive order is a misdemeanor, not a felony, but still, that's enough to get you a nice vacation in Kent County lockup. So that's kind of how that's been handled.
Mark, can I just jump in real quick and just piggyback on a thought there? So, I mean, that's exactly right. Is how do we get our folks back to work? What do we do? And everyone's thinking about performance standards, defaults, getting your folks back to work. But I mean, just the process is a top to down approach. So the executive order requires the owner. The interpretation of the executive order requires the owner to designate the project as critical infrastructure, but then requires all the lower tier contractors and subcontractors to do the same for their subs and suppliers. So the owner designates the CM of the GC, then the GC has to determine their subs and suppliers that are critical infrastructure workers, and then the subs need to identify their subs and suppliers that are critical infrastructure workers. Not everyone's going to be a critical infrastructure worker, right? The person at the hospital, the landscaper who's putting the flowers in the ground is not going to be a critical infrastructure worker. So that's the approach. But here's the scenario outside of the violation of the executive order that is a monetary fine and also a misdemeanor punishable by 90 days in jail. I mean, that's a serious consequence, right? But think about the bigger picture, the liability associated with if an owner makes a designation and it's incorrect. I mean, there's some that are so clear that are right within the executive order, but there's some head scratchers. If there's a head scratcher and you as the subcontractor or the general contractor is designated as a critical infrastructure worker and you don't agree with that, you need to do your own independent analysis to determine how comfortable you are, because here's how that plays out. If it is an improper designation and you are not a critical infrastructure worker, and you just go with it, what happens when one of your employees contracts COVID? And what happens when your employee dies from COVID? then now there's a wrongful death lawsuit against you, against the general contractor, and against the owner. So other than the $500 penalty for violation of the executive order and the 90 days in jail, those are huge risk factors that you have to consider when you're doing your own designations and own due diligence about what critical infrastructure is. And just think about how that plays out in a lawsuit too, for a jury trial, for a wrongful death. Everybody in the world has experienced and knows what's going on with COVID and has some emotional responses to it. So think about a jury looking at a subcontractor, a general contractor, an owner, and saying, why did you designate that as critical infrastructure? Why did you put people back to work that then contracted COVID and then had serious consequences from it? So that's the bigger picture as far as risk management that people just aren't talking about, which is beyond performance standards, beyond contract standards, beyond getting folks back to work, is those huge liabilities and consequences that can come from not doing the right thing or not doing your own due diligence.
Good point, Stan. Thank you. Got a couple other questions here. Is there any talk about non-essential construction projects that are currently banned being permitted to go back to work before other industries? Not that I've heard of. I haven't heard any rumors, gossip, haven't got any tickles in the back of my brain that the governor is going to amend her executive order anytime soon. It's certainly a possibility. I think that the probability of some amendments to that happening increase if the time period that we're all subject to the executive order continues to lag out. In other words, the further the executive order applies, I think there'll be more modifications to it. But I think it's unlikely that non-essential construction projects are going to be permitted to continue while this is going on. The way that I see it, at least, and it's very open to interpretation, is that the governor took a position on what she was going to allow and not allow. And those of us that have dug into some of the other states will be the first ones to tell you that Michigan's executive order doesn't align with the executive orders from other states and even the federal government's recommendations on this issue, at least as it relates to the construction industry. Michigan is probably at the very far end of the spectrum of very limiting to the construction industry right now. I don't know why that is, but that's how it is. So we have to live with it, I suppose. The next question is, what happens if an employee that is working contracts COVID-19? Do you think that they could successfully file a work comp claim? It's an interesting question. I think that there's a chance they could. I think the biggest problem that anybody has that wants to assert any type of claim, like a personal injury-based claim or a workplace injury claim, is going to be establishing that the injury occurred during their work. I mean, frankly, we're dealing with an invisible virus, right? That's how we hear it described on national TV every night, as the invisible enemy, the war we're at with the invisible virus. It would be very, very difficult to even come up with some type of really argument even about how somebody could prove that they contracted a virus on a specific day within a specific time period. I just don't see it operating in a way that gives us that much of a definitive answer about the causation effect, if you will, of how a healthy person went from being healthy to being sick. What caused that, other than we know they got the coronavirus? Where did they contract it? How did they contract it? How do you know they contracted it on the job site or at your office as opposed to at home? And so from a work comp perspective, I wouldn't be that worried about it, because frankly, let them make the claim. That's what you pay insurance for. They'll deal with it. The difficulty that an employee probably has in even getting off of first base on that is, like I said, establishing that the injury, being contraction of coronavirus, happened at work. and they're going to have the burden of proof on that. So it would be, I think, a very tough situation to try to get a comp claim covered on that. But and the other part, I think, is that we're going to see, and this is just me pontificating, but we're going to see insurance companies pushing back on coronavirus-based claims. Frankly, they have a ton of exposure because of coronavirus and how it impacts the risk transfer that they've assumed by issuing policies of different types.
Yeah,
yeah, go ahead.
Just real quick on that, Mark. Other issues with that. So Michigan's standard for works comp is the injury has to arise out of or occur during the course of employment. And Mark touched on that. I mean, the burden's going to be on the employee to show where they were exposed, how they were exposed. Were there other employees that exposed them, or did they contract it, weeks before for being out in the general public? So, I mean, that's going to be a pretty high standard. But even if they are able to prove that, I see issues with why are you claiming workers' comp when, like we talked before, you could claim paid sick leave under the Paid Sick Leave Act, under the COVID Response Act. So those are other arguments that if they do come to you with a workers' comp claim, then you have to do an analysis of, well, do you want to pay them under the Paid Sick Leave Act for up to 80 hours or 2 weeks? Or do you want to have them make a claim on workers' comp? And that just depends on the individual and their, individual situation. But I think that would be another argument is, number one, you cannot double dip. You could not get paid leave or, payment through workers' comp for COVID, and then also double dip into the Paid Sick Leave Act too. And there could be an argument that you're not entitled to workers' compensation because you're entitled to it under the Paid Sick Leave Act.
Good job. Thanks, Dan.
Yep.
Well, we're approaching the top of the hour here. Got about another 6 minutes. I know everybody's got other stuff they probably want to go do. Here's what I'll kind of close with. And first, I want to thank Nell, her team, and also Chris and Dan for doing all the heavy lifting today. And I'd like to encourage everybody that participated to do a couple of things. One, reach out to Nell or myself or anybody on the ASA board and share what you thought about this program. I mean, part of what we wanted to do was roll out a program that was a lot more interactive. And we did so knowing that this is really a trial run. Some things probably didn't work as well as we'd hoped. Other things maybe did. But we want to continue to have ASA be a resource for you guys. And we want to continue to be able to try to provide you with timely and good information. And I think that from my perspective anyway, the best way to do that is with a very dynamic process. You guys raise the questions, we talk about it, and we try to develop some information and give you the information that you want, as opposed to just dumping information on you that may not be of interest. So good, bad, or otherwise, let us know what you thought about this. We're here for you guys. And so the other thing too is we're around. If you have a question or you just want to catch up, give me a call, send me an email. We can chat. I'm not going to bill you for it. If you want some of the resources that we have, we're happy to talk about that. I mentioned the OSHA guidance for employers. Happy to circulate that. Happy to circulate other things. So the biggest thing that'll get us all through this is the community sense of West Michigan. I mean, we as a community have that in spades, and we are already coming together to collectively move past this and through it. And so let's continue to do that, and let's keep it an open process and try to give you guys what you need and what you want. So thanks for listening. Everybody be safe and healthy, and I'll turn it back over to Nell, and we'll see you next time.
Mark, thanks so much. And I just want to reiterate what he said. Please send me your feedback so we can continue with this dialogue and do it again, maybe in this format. If it didn't work, we can look at something else. We appreciate everybody taking the time out this morning. We know everyone's inundated with information and super busy. So thank you to Dan and Chris for participating, and for, all the people that jumped on the call today. I think we had about 30 people. So thanks to everybody. Have a great day.